On behalf of the Klaus families and the Berry families, we would like to extend our sincere and heartfelt gratitude to the following people. Thank you to the Castor Fire Department for their quick and efficient response to the fire at the Klaus Farms on December 8th, 2013. Thank you to the RCMP, the Major Crimes Investigation Unit, and the Undercover Unit for their amazing dedication and their extreme hard work. Thank you to the lawyers for the Crown, Doug Taylor, Ann McDonald, and Dallas Sopko for their very intricate and incredibly precise presentation of this case. Thank you to Honorable Mr. Justice Eric Macklin for his much appreciated expertise and wisdom. Thank you to the courthouse staff and the security personnel for going above and beyond when asked to do so. Thank you to Brady Flett for undeniably risking his life for Monica. Thank you to Joy Brown for her always kind and knowledgeable assistance to the families. Thank you to the staff of Victim Services for their encouragement and professional help, as well as supplying Ringo, the Black Labrador dog. Thank you to the media for your thorough coverage of this case, as well as being respectful of the family's wishes. Thank you to the many family members and friends for all their constant support and sincere kindness over the past 4+ years. Although this does not bring Monica and Sandy and Gordon back, we are very grateful that justice has been served and that we now have the opportunity to move forward with our lives. Thank you.
I thought the judge gave a very well-reasoned, extensive decision, and I certainly accept his decision.
Disappointed though?
No, not a bit.
Why wouldn't you be?
Well, the sentencing is the province of the trial judge, and the Crown made its submissions. We felt we made the submissions that were appropriate and gave him the ammunition he needed to consider the parole eligibility, whether it be concurrent or consecutive. He heard what we had to say. He clearly echoed what the Crown had to say in its submissions, and he ruled as he did. I accept that.
Given the gravity of what these two men did, do you think that they have a chance at parole after 20 years?
Oh, I don't have any comment on that. I think the judge covered that in his decision, and they, of course, will have to face the parole board. And as we all know, that just because they can apply at 25 years doesn't mean they're going to get parole at 25 years, or ever for that matter.
Justice Macklin spent some time at the end talking about, in general terms, 74551. What were your thoughts on some of the things he had to say about the legislation?
I thought that the judge had given it a great deal of consideration, and he had some things that he wanted to say, and he did. And I respect his approach and what he had to say on the issue.
Any thought of a possible appeal?
Oh, that's not for me to decide. But at this time, I can tell you that cases of this kind are always discussed by the executive directors at Alberta Justice, and this case, like all others, will be considered, and we'll find out in due course.
Do you think it's any consolation to the family today of the victims?
I don't know what consolation the family could have in this. I'm hoping, as the judge said, that they find a measure of peace in this. I think, as the judge pointed out, that in many ways nothing will ever assuage their pain or make up for the loss of their family members. It's a terrible crime. That's been said by everyone in a number of different ways, and we just hope that they go on and they can find some peace and carry on the memory of their loved ones.
That's what I asked for. I think, of course, there was an extremely carefully thought out and well-reasoned decision by Justice Macklin. I think he considered all the factors that were necessary, imposed a sentence which reflected the egregious nature of the acts that he found my client guilty of, but yet recognized that everyone is capable of redemption, of rehabilitation, and left that possibility open. Again, I think one important takeaway from his decision is the fact that no one should walk away from this thinking that at 25 years my client will walk out of jail. That will be up to the parole board. And as Justice Macklin pointed out, there are very few multiple murderers in the Canadian jails who obtain parole at 25 years or very soon thereafter.
Justice Macklin took some time to talk in general terms about 745.51 there as well. What was your take on some of his comments about the appropriateness of the legislation?
Well, he noted that it was not a mandatory piece of legislation. It left the court with discretion, and And I think that's important because one of the things that's concerned me for the longest time is the fact that discretion seems to be taken away from trial judges on a regular basis, and there's no one in a better position to determine what's appropriate than the trial judge who hears the evidence. But he also recognized that that particular section does leave consecutive periods of parole ineligibility open for the most severe and egregious cases. And you know, so it was important that he touched those particular points.
Do you think his comments were any solace to the people who are?
How can they be? These people have lost family members, they've lost friends. A well-loved and respected family in the community has been taken away. Nothing that happens in these courts, no matter what Justice Macklin's decision would have been, would have brought that back to these people. The term closure gets tossed around a lot. I personally don't believe there is such a thing. How can you ever get closure on something like this?
What does your client think of the sentencing?
Relieved. I think encouraged. You know, I think Justice Macklin's point that to impose a sentence sought by the Crown would totally remove any hope of rehabilitation and thereby make him less likely to try and improve himself was a very important point, and I think it's one my client certainly takes to heart.
He determined that 25 years parole ineligibility is appropriate versus the 75 years that the Crown was seeking. We think it's a fair decision. It was a well-reasoned and thorough decision. Regarding our next steps, we'll have to review the decisions, review the trial transcripts, and make any recommendations moving forward.
Do you plan to appeal?
At this stage, we're just reviewing the trial transcripts and the past 8 weeks of this trial.
Thoughts on the Justice Macklin's comments about the ineligibilities, the consecutives?
You mean the legislative
Yeah.
comments he made regarding that? In my respectful submission to the to Parliament of Canada, I think that his comments were fair, and as I stated, they were well reasoned, especially the participants in the justice system who actually understand the definitions of denunciation, deterrence, and the actual ramifications, if any, of longer penalties and the impact they have on the accused or the offenders that are sentenced. There is actually contrary evidence that indicates that longer sentences do not deter.
Have you had a chance to speak with the family?
We spoke with them prior, and we're going to have further conversations afterward.